Good morning, everybody. Welcome to oral argument before the California Supreme Court. The clerk may call the calendar, please.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco, Wednesday, May 8, 2024 at 9 a.m. Case number S281977. Legislature of the State of California et al. Petitioners. Shirley N. Weber, as Secretary of State. Respondent, Mr. Thomas W. Hiltachk, real party in interest. For petitioners, Ms. Margaret R. Prinsing. And for real party in interest, Mr. Thomas Hiltachk. Case numbers S269099 and S271493. Golden State Water Company petitioner versus Public Utilities Commission respondent. California American Water Company et al. Petitioners versus Public Utilities Commission respondent. For petitioner, Mr. Joseph M. Karp.
Ready.
And for respondent, Ms. Darlene M. Clark. Case number S271721, Tina Turrieta, plaintiff and respondent versus Lyft, Inc., defendant and respondent, Milan Sefu et al., interveners and appellants. For appellant Brandon Olson, Ms. Monique Oliver.
Ready.
And for respondent Tina Turrieta, Mr. Alan Graves.
Ready.
And for respondent Lyft, Inc., Mr. Felix Schaffer.
Thank you. Calling the first matter, the Legislature of the State of California versus Shirley N. Weber, Secretary of State. Good morning, Counsel.
Good morning, Your Honors. May it please the Court. Margaret Prinsing on behalf of the California Legislature, Governor Gavin Newsom, and John Burton. We appreciate the opportunity to address these issues here today.
Thank you. And Counsel, you've requested 8 minutes of rebuttal.
Correct. The initiative measure before this Court is unlike any that has come before it. While other measures have burdened or restricted the power of the legislative and executive branches, this measure would fundamentally restructure the power of government to raise revenue as set forth in the California Constitution.
Counsel, I'm going to interrupt you just from the beginning, and I'm sure that we'll get into all of the details about the initiative and the challenges to it. I just have a threshold question I'd like you to address first as to the pre-election review and why this court should consider it and not put it on the ballot instead of allowing the voters to consider it.
Absolutely, Your Honor. So, under this court's precedents, the general rule is to delay review until after the election. However, that this court in Legislature versus Duke-Majan said that is based on the assumption that the delay will not require negative consequences. And in this instance, because of the retroactivity provision in the measure, delaying review will cause negative consequences and is already causing negative consequences. As a reminder, the retroactivity provision here reaches back over a 34-month period to January 1, 2022, and it puts at risk every tax measure that was passed in that period that doesn't fully comply with the measure, and every newly defined exempt charge. And as a consequence, governments right now, as we speak, up and down the state, they're in the budget season. They're trying to balance their budgets. And they have to do so without knowing what amount of revenue will be reasonably available to them, because if this measure passes, they may lose multiple sources of revenue. So that is already causing a great deal of harm, and as we move towards the election and after the election, the harm will only continue.
Counsel, couldn't we take an approach similar to the one we took in Briggs versus Brown, where we stayed implementation pending our post-election review, and I think eventually stayed the effective date of the initiative? Why isn't that a possibility here?
So if the court were to stay the retroactivity clause in the sense of tolling that 12-month period that governments would have to bring tax statutes and exempt charges into compliance with the measure, that might mitigate the harm. And I say might because, as I've mentioned, the budget process is already going. It's it's happening now, and governments are having to make decisions now based on this uncertainty. So what you've suggested might help mitigate that harm, but it's not going to eliminate it. Because even if we could remove or lessen the uncertainty for this budget cycle, governments have to engage in long-term planning. And even if the retroactivity clause is stayed, that really prolongs the uncertainty and makes it difficult for governments to engage in that long-term planning that is necessary.
But it would freeze frame. It would freeze frame these concerns that you're outlining in terms of the budgeting process, sufficient for this court to vet the initiative, correct, and then add certainty.
Well, it would freeze frame it in the sense that it would give governments more time in order, if the measure were to be enacted, where they could then try to bring the measures into conformity. But that's not the chief harm that we've identified. The chief harm that we've identified is the uncertainty that is now infecting the budget process and the government process in general. I can point, for example, to the amicus brief that was filed by United to House LA Coalition. And Measure ULA in Los Angeles is a measure that both real party and interest and petitioners agree would be subject to the retroactivity clause. And as the coalition outlines in its amicus brief, because of the uncertainty of whether that revenue will still be available, and this is revenue that the voters approved to combat homelessness in Los Angeles County, the city of LA, aware of this measure, has capped spending under the measure to $150 million, regardless of what revenue may become available. And they've limited the spending to certain programs. And so right now, as we speak, this measure is already having a detrimental impact in just that one circumstance by preventing money flowing to homelessness, one of the issues that many of us in California agree is one of the most urgent problems facing the state. In addition, the coalition identifies that the time frame that they would be operating under if this measure stays on the ballot in November. In order to meet that 12-month time period, the initiative, they would have to begin circulating the initiative again in December, and that means starting the campaign, starting the planning process even before the election. Now, potentially staying that 12-month period could mitigate that harm, but again, the other uncertainties that I'm talking about would remain. And then I also want to mention some additional harms in delaying this until after the election that have been identified by this court. In Senate v. Jones, this court noted that when an invalid measure stays on the ballot, it steals time, attention, and money away from the valid measures that are on the ballot. Those harms are going to begin this summer when the campaigns and the voter attention starts focusing on the measures that are on the ballot. If this measure is on the ballot, it will steal time, attention, and money away from that.
Shifting back to your point about the merits of the challenges, there are, depending on how you count it, there's different challenges. Primarily, there seem to be three. And as an example, you focus on the need to submit new or increased taxes to the voters for them to approve it. And you talk about the harmful impacts and state that that alone constitutes a revision to the Constitution. Are you asking us to look at each of the individual impacts in isolation, or are you asking us to consider the totality of the circumstances in making our decision here?
We are absolutely asking you to consider the totality of the measure. And that's really for a couple of reasons. The measure as it exists is not just an ad hoc collection of various changes that are revenue related. It is a comprehensive measure that is intended to fundamentally restructure the way government power is exercised to raise revenue under the Constitution. So while we do think that it is possible for the court to simply look at the one provision that you've identified, Your Honor, or some of the other provisions like the shifting of power between the legislative and executive branches, say that that alone constitutes a revision. It is really the entire measure that shows the revisionary sweep of what
If we held that the measure as a whole constituted a revision, does that admit the possibility that particular components of it might not?
Well, I'm going to return to the fact that this measure, as drafted and as would be presented to the voters if allowed to do so, is a comprehensive measure.
Yeah, I get that. I mean, I guess the question for us is, if we take this holistic approach that you suggest, does that mean that initiative proponents could then break up the measure essentially into 3 or 4 component parts and then seek individually to enact each one?
Well, I think there are provisions in this measure that, if presented on their own, would not constitute a revision, but could constitute an amendment, and therefore could be presented to the voters in that way. There are some provisions along those lines, but the provisions that we've highlighted are the main provisions in the measure. And that is clear not just, I think, from the briefing before the court, but also from the text of the measure itself, in the findings, in the statement of purposes. It outlines the various purposes that the voters have in enacting the measure. And it lists all or nearly all of the provisions that we're challenging here.
I understand that. So, I mean, let's just take what I think in your briefing is the primary measure about subjecting state taxes to a vote of the electorate, right? Is that a revision in and of itself?
Yes, Your Honor, we believe that it absolutely.
Okay, so we don't need to go further then. If that is your position and we agree with it, then we don't need to go further.
Correct, Your Honor.
Okay. Can we focus on that for 1 second? So, do you have a sense of, just kind of on an annual average basis, how many statutes or how much legislation that affects?
So that is a good question, Your Honor, and in an attempt to answer it, I will point to the Kaminsky Declaration that we filed in connection with our papers. And that declaration identifies 15 state measures that we believe could be subject to the measure's retroactivity clause. And so in that sense, I think that it does respond to your question. How much that breaks down on an average annual basis, I'm afraid I can't say. But I do want to point out that scope is within the bounds, I mean, in that frequency, that number, is within the bounds of what this court has said in the past is revisionary. So here I'm referring to Raven versus Duke-Majan, where this court discussed the existing, how Prop 115 would change the scheme that existed at the time. And that scheme was the courts sometimes voluntarily deferred to federal courts for purposes of interpreting parallel constitutional provisions. But sometimes the state courts would not do so. They would depart from federal precedent when they had cogent reasons to do so. And this court listed out the number of times that had occurred. And I believe it was 8 times in 16 years. So that was sufficient to constitute a revision in Raven versus Duke-Majan. And I think...
Raven isn't a qualitative analysis, is it?
It's not, Your Honor.
Right, and so the question that led us here was really trying to get a sense of the number of statutes that are impacted, that portends of the sort of qualitative analysis that we have outlined in our jurisprudence. But I thought the thrust of your position is that, in fact, the legislature's core power to initiate taxation is relegated to a position of proposing taxes under the definition of tax in the proposition. I thought that was your core position.
Absolutely right, Your Honor. That is our core position. I was simply trying to respond to a question that Justice Liu raised. But that's it exactly. From the beginning, from the founding of the state, the legislature has had the supreme power of taxation, and this measure would revoke that power for the first time in the history of California and instead put it in the hands of the voters.
I want to make sure I understand your back and forth with Justice Liu. You answered both, look at this measure in terms of totality, the key parts together, look at them in a holistic fashion. You also answered, quite understandably, if you just look solely at the measure, at the component that you've focused on in the briefing, and you're discussing now the impediment upon the legislature's ability to pass taxes, that alone would constitute a revision. So how do you want us to rule? Based on one or based on totality? What are you asking for?
Well, Your Honor, we're asking the court to find that this measure constitutes an unlawful revision so that it can't appear on the ballot. And I think there are different ways for this court to get there. We've been focusing so far on the profound change to the legislative power, but we think the changes in the shifting of power between the legislative and executive branches is also profound and is also of a revision standing on its own. So to really get to the heart of your question, I think the court has multiple ways it could get to the ruling and provide the relief that petitioners have.
Can I ask you on the totality analysis, it's sort of to suggest that there may be a different answer if we look at these provisions together than if we look at them separately, which is what I understood your response earlier to Justice Liu to be, would suggest a mode of analysis that's pretty different from how we ordinarily engage in constitutional adjudication, right? So usually we look at the constitutional validity of different provisions of an enactment individually, unless there is some sort of operational connection between those different provisions. And I guess I'd like to understand a little bit why you think the kind of review we're doing here, where the question we're answering is whether this is an amendment to the Constitution versus a revision to the Constitution, calls for a different kind of analysis. What is different about the question we're answering here?
Well, I think that the measure, as we've said, has been presented and would be presented to the voters as a comprehensive series of changes. So any part of it that is revisionary makes the measure revisionary. Now, in order to engage in a more segmented analysis, the court or a court would have to find that the measure is severable. And we don't believe the measure is severable. And this goes back to the comprehensive nature of the measure itself. So for a court to find it severable, among other things, the court would have to determine that if some of these other provisions were to be struck down as invalid, the revocation of the legislature's power to tax, the shifting of authority between the legislative and executive branches, the court would have to determine that the voters would want the rest of the measure to stand on its own, that they would have approved that measure without the offending provisions. And we don't believe this is severable because, again, just on the face of the measure, if you look at the statement of purposes, it goes through many of the provisions. The voters enact this measure for one purpose, for this purpose, for this purpose. So if you take some of those provisions away, then the purpose of the measure has been defeated. So the measure isn't severable, and I think that if one provision or two provisions, which are absolutely the main key provisions, then the entire measure has to fall.
So I think we haven't really gotten to the heart of your argument yet on the merits. And so if I could ask you to sort of focus on that. So let's go back to the tax part. So yes, it's true that the legislature has long had, since the beginning, this power to tax. I guess that kind of argument could be made in any of these kinds of cases because, after all, what is being proposed is a change to the Constitution. So if you could tell us a little bit, what is the significance of the legislature having this power as opposed to sharing that power with the electorate? Why would that be such a major transformation?
So, first of all, just to respond to a point in the question itself, while it may be true that any ballot measure makes a change in the Constitution, what qualifies a revision as a revision is that it's a fundamental change in the structure of government and its powers. And that's what's happening here. It's a fundamental restructuring of the government power. But with respect to the power to tax, this court has described that tax in Watchtower versus County of LA as probably the most vital and essential attribute of government without which government cannot function. And what we would be talking about here with this measure is the legislature would no longer have that power. It would instead be delayed through the voter approval requirement and would be in the hands of a body that is not the legislature. Furthermore, this court has talked in other cases, often in the referendum context, about the need for the legislature specifically, as opposed to the voters, to have the ability to act on tax matters independently. So in Wild versus City of Dunsmuir, for example, this court talked about how it's necessary under the power of the referendum to carve out a space for the legislature to be able to act independently to ensure that essential government services could be provided.
Is this, okay, so, you mentioned Wild. So is this really about delay and uncertainty?
It's really...
That part I get. Okay, let me just say, that part I understand. But I'm wondering if there's more to your argument about the structure of government, the nature of politics, qualitatively. What do you envision happening? Other than delay and uncertainty, which I understand. I mean, that's built into the measure because, of course, if you have another step in the process, you're going to have that. But, I think their argument is, but that promotes a certain kind of accountability, right? I mean, that's in the name of the measure, right? So I'm asking you, on your side, what do you think is the change qualitatively?
So with respect to this one provision that we're chiefly focusing on thus far, and I've gotten to 23 minutes, so I'll try to wrap this up unless Your Honors want to continue this. The revision inquiry really looks at the change in the structure of government and the power. And this particular provision of the measure helps illustrate how that operates here. So if the power to tax is taken away from the legislature and given to the voters, then taxing becomes qualitatively different in the state of California, because the tax that the legislature might propose in order to secure a two-thirds majority of the legislature could be very different than the tax that would be proposed to the voters. So you have a qualitative change there. And you also go from having decisions about taxes being made by a full-time legislature with professional staff who have the capacity and the ability to make revenue decisions in the context of the entire system of California government. They know all the revenues that are coming in, the revenues that aren't coming in, the spending priorities that have flexibility and do not, and the legislature can make those revenues in that context. The voters simply don't have the capacity to do that.
Can't that same argument be made with respect to direct democracy for virtually any topic in terms of the voters' level of engagement or expertise versus full-time legislators?
Well, again, I'm happy to continue, but I've gone over my time.
Answer the question, and then we'll wrap up. You can reserve the rest of the time, and we'll give you more if you need it.
Absolutely. So I'm sure that argument could be made, but we're not making that argument in general. We're making that argument specifically as it relates to taxes. And that's based on the role that the Constitution carves out for the legislature on taxing purposes. And that's in Article 2, Section 9, by exempting tax measures from the referendum. And it's also based on this court's precedents. I've talked about Wild versus City of Dunsmuir, but this court also made statements in Rossi v. Brown about how if taxing decisions were subject to voter approval, then it might become impossible, and it would certainly be delayed, for the legislature to try to pass a balanced budget or raise revenues that are necessary for current operating expenses. So it really does come down to what this court has described as one of the most vital and essential attributes of government, the power to tax, and what that would do to our system of government, and what that would do to the fundamental government powers if that were taken away from the legislature. And in that way, it's unique from other kinds of changes that are clearly within the voters' power of initiative.
Thank you, Council. We'll allow you to reserve the rest of your time. And we'll now hear from Mr. Hiltachk.
Good morning, and may it please the court. Tom Hiltachk on behalf of Real Party and Interest. Let me start by addressing the issue of pre-election review, since that was a question raised. This is most decidedly a case that begs for post-election analysis, and there are multiple reasons for that. First of all, it's possible that the Taxpayer Protection Act may not apply, so we're dealing with speculation upon speculation upon speculation. Many of the effects of Taxpayer Protection Act are mostly speculative. In fact, they're all speculative and based not on evidence submitted to this court, but on the opinions of people in the government who do not want change. But most importantly is the issue that we were just recently discussing, which is that there are remedies available in a post-election environment that are not available in a pre-election environment, most notably severability. Raven being the perfect example. The initiative in Raven, Proposition 115, was not struck in its entirety. This court struck one provision of Raven, having found it to be a revision. In fact, the only case that has ever found any provision of the Constitution to be a qualitative revision. And so I believe that this case most decidedly should be decided after the election.
But wouldn't the mode you describe, post-election review with the opportunity for severance, have its own concomitant speculation problems, to use your word? Because then we're sitting in a posture, if severance is the available remedy of saying, well, we think this initiative probably would have qualified even if it didn't have section X, Y, and Z, and we think it probably would have voted, it would have passed upon vote, even if it didn't have section X, Y, and Z. That feels speculative too, doesn't it?
No, it doesn't. And the reason is that this court has identified factors that it can consider to answer those questions. So the three tests of severability are grammatically severable, functionally severable, and is there intent behind that? A campaign, ballot arguments, ballot materials, all of that reflect on those issues. So the court would not be speculating. This court would actually have facts, would actually have evidence that it could consider to make that determination.
Right. I like to think that any of the factors we lay out are imbued with perfect infallibility. But again, you're saying, well, we can use rules like grammar to know how voters would have voted. There's some speculation in that, right?
The grammar test is whether it's
or the
easy
ballot
to do, right?
This was not a primary focus. X was more a primary focus of the ballot materials than Y, so we know how voters would have voted if not for this provision. You won't meet me halfway and say that requires some degree of the voters would have done X if they had a ballot in front of them that looked different than the one that was actually in front of them?
I think the history of this court with respect to consideration of voter intent, not just with respect to issues of revision or importance, have been used to determine legislative intent, where you don't have that process in the enactment of statutes through a legislative process. This court has relied on ballot materials extensively to consider those types of questions. I think it's equally suitable here. And in fact, this court has done that in cases like this, including in the Reagan case.
What about the present ongoing detriments that your counsel on the other side has identified? You don't think
I don't believe they exist. To the extent they exist, they are largely a function of local governments choosing to ignore the fact that the Taxpayer Protection Act has been qualified. It was submitted more than 2 years ago. Local governments have had an opportunity to bring any measure that has passed into compliance from the get-go, and they still could. And so, to give you an example, Council mentioned Measure ULA. Measure ULA was an attempt to use the so-called upland loophole to enact a tax that would otherwise have required a 2/3 vote, clearly, prior to upland. There's no resolution of this upland decision by this court. It's not clear that Measure ULA is legal at all. In fact, Measure ULA is the subject of a lawsuit. Thus, the city of Los Angeles has to be concerned about whether it can count on Measure ULA income because that measure is subject to challenge. So, over the long haul, this court has long said that local governments are not entitled to any form of revenue forever. It's always subject to change.
Counsel, can you speak to what was in the amicus briefs by 3 individuals who are probably the most knowledgeable in terms of finance for state government? They speak to, and there are others who speak to, the need to be able to respond quickly in emergencies and provide various examples. And I was wondering, do you agree that if the measure had been in place, those same types of remedies could not have been implemented in the same way?
No, and there's multiple reasons for that, mostly based on historical fact. The state has faced emergencies in the past, and the state has recovered from those emergencies in most instances without ever choosing to raise revenue by taxation. This is $250 billion budget, state budget.
So an emergency appropriation for PPE in the pandemic, which would be impacted, wouldn't it?
Well, most emergencies in California or in the nation, the federal government is a backstop and provides relief. In fact, has provided significant relief in California emergencies in the past. Loma Prieta being an example. I think even the amicus briefs suggested that the federal government covered 75% of the cost of Loma Prieta.
But they also say that that cannot be relied upon, and they need the flexibility to be able to respond quickly themselves.
And in the past, in fact, during the Great Depression, when the legislature thought it might need some more revenue via taxation, it went to the ballot. It asked the voters whether they should approve taxes to get out of the worst economic condition the state has ever faced. So the legislature has full power to call an election at any time and to ask the voters to solve a problem that it believes needs solving. But more fundamentally, we have state mechanisms in place to deal with emergencies. We have emergency reserve funds. that did not exist many, many years ago, have been added by the voters into our Constitution over the last 20 years. So we have funds available. We have the authority in existing law for the governor to draw funds from any location to deal with emergencies. So in terms of just the immediate impact of any emergency, there are mechanisms in place to respond to that. And if the legislature believes it needs a more long-term solution, it can certainly ask the voters.
So setting aside emergencies, and I know there's some disagreement about that, I want to go to what I think is another part of the heart of your opponent's argument, which concerns the structure of government and the sort of relocation of the power, which is very, I think everyone would agree, is very fundamental to government, right? That statement, of course, does not dispositive of whether the legislature should have that power or the electorate should. But I think there's one line of thinking, which is that we have a Republican form of government, don't we? I mean, generally speaking, we have elected representatives that help to distill the public will, deliberate, take facts into account, have a long view, have a broad view of things. We also have in this state direct democracy as a result of the early 20th century changes. But those, I think, were meant to act as a check, right, on the basic Republican form of government that we have in the event, as historical example suggests, of capture of those elected representatives by forces that the electorate would not want to govern them. Okay. Doesn't this measure essentially shift us from a Republican form of government far more strongly towards a direct democracy, given how fundamental the taxing power is? And isn't that the major reworking of government that is achieved by this measure?
No, I don't believe so. And I think this court answered that question in Amador, where that issue is raised specifically. But let me tell you why I don't believe that's true, even before 1911 and the enactment of the initiative of referendum power. Because our Constitution, since its inception, has stated that all political power is inherent in the people. It has stated that the people have the power to reform and alter their government whenever they decide it needs reform. So I don't believe California has ever been a pure Republican form.
Well, the same Constitution from the very beginning also contemplated a difference between amendments and revisions.
But it also contemplated voter consent over certain matters, including the ability for the government to go into debt via general obligation bonds.
But doesn't that exception just prove the rule, which is that was a specific carve-out from a general power of taxation that the legislature had?
No, I don't think it proves the rule. I think it shows that voter approval has been a component of California's history since its inception, and that the extension of that to other matters is perfectly within the realm of reason. But at least since 1911, and the enactment of the initiative referendum power, which addressed the issue of taxation specifically, which this court identified in the Rossi case, has noted that the power of the legislative branch is shared. It's a shared power between the people and the legislature. So there is no unilateral power of the legislature to impose taxes.
I think it's shared in the sense that, of course, there are these direct democracy checks on what the legislature does. But I think given how fundamental the power of taxation is, wouldn't your proposal essentially create a fourth branch of government?
Absolutely, no. In fact, I believe that's actually the argument that the petitioners are making, is that the people are in fact a fourth branch of government. It's actually the only way that they can make the argument under Raven that there is a transfer of power from the legislature to another branch of government. I believe that to be false and simply wrong, because this court has never said that. This court has always said that legislative power is shared between the people and the legislature. And in the area of taxation, that could be no more evident than in recent history, Propositions 13, 218, Prop 62, Prop 26, but even going back to just 5 years after the initiative process was enacted in 1911, there was an initiative measure, a constitutional amendment, placed on the ballot in 1916 that would have imposed a single form of taxation in California by repealing every other form of taxation in California. That measure did not pass.
Mr.
But the
Hiltachk.
response by the
go ahead.
legislature to that initiative was to ask the voters to repeal the power of taxation from the initiative process in 1917. That did not pass. So what we have is essentially a two-way street where the legislative power is shared amongst these two groups, the people on the one hand, the legislature on the other, but that the people have the last word.
Can I focus your attention to shift to another area on what seems to be and has been described as the dramatic expansion of the referendum power, whereas in the past it had certain limitations to exclude most revenue laws. And now the argument is that a minority can now really hold up billions of dollars in revenue as a result of the definitional changes that have been proposed through this measure. Isn't that a fundamental change in the functioning of our government?
No, and I don't believe TPA does that at all. And when I say TPA, I mean the Taxpayer Protection Act. With respect to the referendum power, the only change affected by the Taxpayer Protection Act is essentially a reversal of this court's decision in Wild, where the court felt that there was an ambiguity about the definition of a tax in the referendum provisions, and that because a referendum of taxes is not permitted under the Constitution, which I believe, by the way, is a policy decision, not a constitutional mandate, that the only change is that we are saying and making clear that taxes and fees are different, and if it's a fee is subject to referendum, and a fee has been subject to referendum since the referendum power was enacted. And so there really is no fundamental long-term change with respect to the power of referendum.
I guess the nature of the question is that given the number, if you're looking at these provisions of the TPA that have to do with removing from executive decision-making, namely agencies, both at the state and local level, right? The ability to set certain fees, anything that has a revenue, and you define state law extremely broadly. I mean, the measure does anyway. Then a whole lot of things, right, now require legislative approval, and they are now then subject to referendum. So you might say the referendum power is always extended to these things, but the canvas is now extremely broad. Isn't that true? I mean, we're talking about, at the local level, we're talking about things like, it was said in the briefing, things like, park fees, library fines, traffic tickets. I mean, are we, do you agree that the TPA reaches that far? It would seem so by its terms, by its very terms, it reaches that far.
I don't believe TPA does that. I believe the initiative of referendum power has always done that the referendum has always been available.
No, I mean, the TPA, let's be clear, the TPA defines exempt charges, right, to mean any other revenue raising kind of measure. So if a local senior center wants to charge a fee, right, for rental of its facilities, that has to be approved now by city council, right, in order to do that. And it is thus subject to the referendum power, right? If you want to impose a library fine, and you don't give individual due process to the person subject to the fine, that too, right, can be subject to a legislative approval. I mean, this is vast. And your briefing does not deny, actually, that all of these effects are part of the TPA. I guess I'm giving you a chance here. Do you agree that this is part of the reach of the measure?
Yeah, I believe, let's start it at the local level. I do believe that most fees enacted at the local level are in fact enacted via ordinance. It is only in the largest cities in the state of California that have vast executive branch agencies that would be subject matter of those types of things. And so in that instance, those types of fees have been the subject of potential referendum for over 100 years. And the fact that you don't see that very often ought to allay any concerns about that. With respect to state law, what we have evolved into is an administrative state that has far too much power among non-elected bureaucrats who no one knows their name, setting fees not for a fishing license fee, that's not what this is about, but raising billions of dollars out of the economy without any legislative oversight. And so what we've shown here is that the legislature picks and chooses the things that it wants to have a say over in the fee context. My state bar fees are set by a statute. That statute could be subject to referendum. But other fees are not set by statute. They're granted to an agency to make that decision. I'm not suggesting for a moment that that executive branch agencies will have no role in the setting of fees. And in fact, I think they will be the primary determiner of what the right amount of fee is. What I'm suggesting is that in a government like ours, our representatives, to go back to your questions about representative democracy, should not absolve themselves of the responsibility for having any input in
I think that may be good, bad, medium as a general principle, right? We're not, I guess, we're not here to discuss necessarily the merits of the TPA. I think the only question is, how big a change does this work, right, in the structure of government? And if the concern were what you said, which is about billions of dollars being raised by, in your view, unaccountable officials, right, then a measure could be drafted to target those large measures. But that's not how this measure is written. This measure does not have a dollar cap. It does not have some sort of threshold that decides what's a big decision, what's a small decision, right? So we're talking about every decision, down to the library fines, right? And so if library fines are subject to these requirements, I guess virtually anything is in terms of revenue raising, and that's the breadth of the measure. If you wanted a measure, right, that spoke to the concerns that you raised, that would be a different measure. But this measure, right, it seems quite broad.
Prior to the expansion of the administrative state in the last 20, 30, 40, 50 years, all fees were approved, proposed, and enacted by statute in California. And because that was the case, all of those fees were subject to the referendum power. So it is true that more fees, many more fees, would be theoretically subject to referendum power. But it really is just a rollback to a condition that existed decades ago, prior to the legislature deciding that it was going to empower executive branch agencies to raise revenue. Lots of revenue. And what TPA does is restore not only the people's power to have a check and balance on that, but to require the legislature to be part of that process, to have ownership over that process. That's accountability. That's not a revision, and that does not impair essential government functions. I believe my time is about up, but I'd like to close with just one comment. In our view, the Taxpayer Protection Act merely amends existing provisions of the Constitution that were all previously approved by the voters. It does not revise the Constitution in any way. There is no transfer of power from the legislative branch to any other branch of government or any other entity at all. This is a shared power, and this tug of war over taxation has been going on for over 100 years. To reach any other conclusion, this court must disregard 130 years of Supreme Court precedent. Doing so now thrusts this court into making a political judgment it should not make. Rather, that judgment should and must be entrusted to the voters. Thank you.
Thank you, Mr. Hiltachk. Ms. Kensing? You have about 4 minutes, but we did take you over your time, so we'll see how it goes. Thank you.
Thank you, Your Honor. I'll begin with the ending. And with Real Party suggesting that the measure would roll us back to before we had the administrative state, so back to the 19th century. We don't disagree with that characterization, but it goes to the far-reaching nature of this change. This court, in 1917, in Gaylord versus Perry, talked about how the modern state necessitated, made it imperative, is the word this court used, for the legislature to be able to delegate quasi-legislative functions to the executive branch. This measure would prevent that from occurring across a broad range of delegations. That's a far-reaching change in the fundamental government plan that interferes with a power that this court has already described as imperative. The discussion about the referendum measure, I think, was very illuminating. I don't think I need to add much to it. But I do want to make this point that the shift from the executive branch to the legislative branch, and by the way, that is a very clear shift that the measure does make, shifting power between those two branches. But in any event, it sweeps so widely, as Justice Liu suggested. It's not just about fees. So many actions that the executive branch takes at the state and local level, executive orders, regulations, opinion letters, enforcement actions, legal interpretations, other legal authority, whatever that is supposed to mean, all of those things the executive branches would lose the power to do. It would have to be enacted by the legislative branch, making it a statute that would become subject to the referendum. This is a vast change in our fundamental government system.
Could I ask you about the thrust of what I understand Real Party's argument to be about at least the taxing part of this measure? There's quite a bit of history discussed in the briefing, and the basic point, I think, from the other side is, look, you know, this has been going on for a long time. The negotiation of the proper division of roles between the elected representatives whom we have and the power of the people directly to legislate. And all this is another shift in a long-running negotiation, which, as I think Real Party points out, the ultimate power over this ultimately resides in the people. So what is so different about this measure compared to all the other negotiations that have happened in the same vein, I guess, that have occurred throughout the last century at least?
Scope and the nature of the change. So there have been, and by the way, this illustrates how robust the voters' power of initiative is in taxation matters. Regardless of what happens in this case, it remains extremely robust. But let's compare Prop 13 to this measure. Prop 13, of course, many people would consider to be one of the most consequential measures in the state of California. And you may or may not agree, but as this court said in Strauss v. Horton, the measure of a revision is not the importance of the change, but its scope. So with Prop 13, it made relatively discrete changes to the state power to tax. It imposed a 2/3 voting requirement, and it took one tax outside of the legislature's power. This measure would fundamentally restructure, take away the legislature's taxing power over all taxes and turn it into a power to propose. That's a fundamental shift in power that separates it from all the other tax measures that have come before it. And in my waning moments here, I do want to address one other point that Real Party made, suggesting that because the measure would shift the taxing power from the legislature to the people, that it's not really a shift in power since both parties or both exercise the legislative power. A shared power does not mean the two entities are interchangeable. If the two parties were interchangeable, we would have no need for an initiative process. The voters in the legislature obviously occupy different spaces. And in the area of taxation, this court has identified that distinction as important, essential, necessary. And this measure would obliterate that distinction when it comes to taxes. And that is a fundamental change in our government structure, so it's a revision. And it's a revision that would occur in ways that would endanger the government's ability to provide essential government services.
Thank you, Ms. Printing. We appreciate the arguments of both counsel and all of the amicus parties as well. The matter is submitted.